So he called me, and the professor from China, we are waiting. He has not yet joined. So these two
He's not
updates.
going to join actually. I got an email from his assistant that something came up for him.
Oh, acha.
He's not going to be able
So the
to
Chinese
join.
professor is not there. Okay, fine. So maybe David may speak before Mr. Rungta, right?
Yeah, David
And,
and Laura can speak
yeah,
before.
and we can give 5 more minutes to David because David, whatever David told me is so fascinating.
Yeah.
Okay, so I'll go number
Rahul?
3. I'll go number 3, and I've got 15 minutes. Is that the plan?
Yeah, all four of you can have 15 minutes, I think.
Yeah,
12 to 15 minutes.
Yep.
So we can try making sure that
by 7 we can finish the discussion. By 7:15. Sorry.
yeah, so by 7:15 we can finish. Then we can have discussion for like half an hour. We can have Q&A
Yeah.
and then a few questions from the audience. And
Yeah.
then
So that by 8:10 we can finish. Yeah. So Varsha madam, the professor from China, unfortunately he has some issues, so he is not.
Yes, sir. Just one thing, Rahul, if you know the shortcut for accessing the chat box on the Google Meet, it would be helpful because Mr. David was asking for that
I don't
shortcut.
have it. I'm sorry, I don't.
He doesn't know.
Okay.
Yeah.
And you can shift a little bit ahead in front of the screen because I think so you're
Oh,
a
I
little
see.
bit away. Yeah.
Okay. Is better?
Am I okay? Am I
A
lined
little
up with
bit
this
more.
screen?
You can just take your screen a little bit forward.
Are you talking to me?
No,
No,
sir.
she's talking to Rahul.
To Rahul. Yeah.
Oh, okay.
That's okay. Yes. Yes, Rahul. That's okay.
And David is okay, right? His
Yes,
screen
sir.
is
Yes, sir.
fine. Yeah.
Yes. His
David,
screen
your
is
screen
fine.
is fine.
Okay.
Sir, it's already 6 o'clock.
We should
So
begin. Yeah.
I think so. We'll
Just
have to.
wait.
Are we
Just
going to
wait.
wait for Miss Laura to join,
Yeah,
or
yeah.
we are going
Just
to
wait
begin?
for Laura.
Yeah.
Okay. We'll wait. We'll wait. Okay. Because Rahul has spoken, so she would join.
Yeah. She said she'll log in at 7 6 hour time. So
Yeah, yeah. I know.
let's wait for a couple of minutes. She doesn't join, I'll call her.
Yeah, yeah.
Is Carol here? Is Carol Taylor here?
Yeah. Carol Taylor.
Okay.
Carol, whether Miss Taylor is there? Has she joined? Carol Taylor?
No, sir.
No.
No, sir.
Okay. Miss Taylor also we have to Aparna madam listen.
Kindly send her an email to follow up with her to Carol Taylor.
Yeah. I have already spoken about it. Mail is going to her.
Laura is saying she can't hear us. She's in the meeting, but she can't hear us.
Oh, but has she muted herself?
Did you get an option to admit her?
Just a minute. Varsha madam, Laura la admit kare sir.
Yeah.
No.
Now we can see her, sir.
Now we can see Laura.
Yes. Yes.
But she can't hear us, she says.
She has
Okay.
to unmute.
Yeah, she has muted herself, so she.
Control D. She has to put.
The problem though is not that we can't hear her, it's that she can't hear us. So her unmuting herself might not.
I think I'm hearing somebody's screen reader in the background.
That's
Yeah.
fine.
Okay.
Are you able to hear me now?
Oh yes.
Yeah.
Yes.
Okay,
Laura,
sorry.
Laura, good morning.
I haven't ever used Google Meeting before, so I thought I had joined, but I hadn't joined.
You sound like you're using a really good microphone. Which one do you got?
It's a Jabra headset. It's from my work.
Right.
They gave us a bunch of fancy stuff for remote litigation. So,
Laura,
Hi,
this
Laura,
is
this
Sanjay
is
Jain.
Rahul.
hi, good to meet you.
Hi, and I'm David Lepofsky. Nice to meet you.
Oh, good to meet you as well.
I'm sorry about the muff up about the timing. You had to wake up
Yeah,
an hour
yeah.
earlier.
Yeah.
Sorry about that.
We have really disturbed you in the late morning, early morning. Yeah.
Where are you located, David?
Toronto, Canada.
Oh, okay.
You're in DC?
I'm in DC. Yep.
I love Washington.
Yeah.
Get rid of this bloody Corona thing and come back and visit. I love it.
I know. Yeah.
Okay. Yeah. So Rahul, can we start now?
Yeah,
Can
we are just waiting for Carol to join.
Yeah, Carol to join, but just we
in
will
the
wait for.
meantime, and somebody can chase her up.
Yeah, we have already sent a mail to her. Let's see what happens.
All
Yeah.
right.
Somebody will also try her on Facebook, but I think.
So Carol has joined.
Acha, Carol has joined. Okay. Hi, Carol. Hello. She has to unmute herself, Carol.
For those who are visually impaired, Control E mutes and unmutes, or Control D for David mutes and unmutes, and Control E turns on and off your camera.
Yes.
Right. She doesn't have a visual impairment. Though.
No, she's not visually impaired. So
Yeah,
hello.
just telling everybody.
Yeah. Swati madam, Varsha madam, can you tell her to unmute herself? Till a message. Achha.
Hello.
Hello, Carol.
Hello, Sanjay.
Hello, how are you?
I'm good. I do
Good to see you.
apologize.
Good to see you. Yeah.
I appear to have the timing out slightly, and I'm not used to this platform, so I couldn't figure out where the unmute button was. I see now.
Yeah, but now you're fine. Your voice is also okay. Yeah. You have to be just nearer to the screen and microphone. That's it.
So, has everybody? Is it my turn to speak?
No, we'll just begin. There will be some preliminary remarks, and then you will be
Okay.
invited to speak. Yeah.
All right. Thank you, Sanjay.
Yeah. Okay. Varsha madam, now we can start. There is no problem. Everybody is joined. All our speakers have joined. जॉइन सुरू करायचं recording सुरू केलं Varsha madam, you have to also start
Sure, we can hear you.
Yeah.
So recording is started.
आणि ते screenshot sorry
Yes, sir. Transcript is also started.
Transcript. Yeah.
Yes. Am I audible?
Yeah.
Yes, now.
Varsha madam, now you are audible. Yeah.
No, Varsha, we can hear you now again.
Yeah. We've lost her.
I'd like to begin in the interest.
You can remove the ear.
Yeah. Just a minute, Rahul.
Am I audible?
Yes.
Yes.
Okay. Distinguished speakers of today's session, Ms. Laura Wolk, Ms. Carol Taylor, Mr. David Lepofsky, Professor ZHANG Wanhong, and Mr. S.K. Rungta, who would be there within a short while. Members of Governing Body and Governing Council of Indian Law Society, Ms. Vaijayanti Joshi, Director, Academics and Administration, ILS Law College, Dr. Sanjay Jain, Principal, ILS Law College, faculty members with disabilities. Before we proceed to this session, I would like to place on record The support we have received from our collaborators, Harvard Law School Project on Disability, Oxford Human Rights Hub, Center for Disability Studies, University of Leeds, London, Publicity Partners Bar and Bench, and Media Partners Udan. As we are in virtual platform, we would like to give you a glimpse of ILS Law College's work captured in a video by our students.
Spread over 154 acres and is nestled in the lap of the hill in the heart of Pune, the cultural capital of Maharashtra. Its policy is to strengthen the weak and lead the advanced towards perfection. The college offers various courses which include the 5-year integrated law degree, the traditional 3-year law degree, LLM and diploma programs, and certificate courses. The vision and mission of the college guide the path of its governance, leadership, and management. Our objective is to impart socially relevant and professionally desired education to produce lawyers who will uphold the values of justice, liberty, and equality. The efficient leadership has built a culture of law, gender equality, and inclusiveness as the foundation of our education. The college also boasts of one of the oldest law libraries in the country, which is also a proud owner of rare collections of literature, 49 computer machines with high-speed internet and access to e-legal resources, supplemented with the JAWS software and Braille printer for the differently abled. The canteen is an excellent spot to unwind and relax, where the students can enjoy homely and clean food at affordable prices. The college has taken concrete steps in order to make its environs accessible to people with different abilities. Care has been taken to ensure that the hostel is accessible to people with disabilities, with the help of ramps and other aids. This, along with the state-of-the-art sports facilities, allow for a multitude of sports like football, cricket, tennis, volleyball, and a swimming pool, which complement the rigorous work done in classrooms with physical fitness. Under the able guidance of the teaching and administrative staff, the college has established various cells in order to achieve its aim of social inclusiveness and justice for all. The legal aid cell, which is instrumental in providing free legal literacy, is the mainstay of this process. Working towards gender equality, inclusiveness, and social justice by upholding the rights of women, empathy towards the differently abled, and aiding the socially and economically disadvantaged sections of the society form some of our core social responsibilities. These responsibilities are institutionalized in the form of programs, activities, and initiatives taken up through various cells with the help of infrastructure provided to the students. One of the many initiatives taken by the ILS Law College is the Equal Opportunities Come Enabling Cell, headed by Dr. ZHANG, who himself is a person with disability. No other institution in Pune has contributed as much towards the cause of inclusiveness and the change in attitudes, incorporating the immortal words of Mahatma Gandhi. If you want to see a change, you have to be a part of it. The college has produced distinguished legal luminaries, which include 3 former Chief Justices of India, P.V. Gajendra Gadkar, Y.V. Chandrachud, and E.S. Venkataramaiah. While the students and teachers strive to achieve these lofty goals, the sister institutions of the ILS also play a role in helping realize this dream. Institute of Advanced Legal Studies, Center for Mental Health Law and Policy, Indian Law Society's Center for Arbitration and Mediation,
Center for Health, Equity, Law and Policy. We welcome you all to the ILS Law College.
Thank you, Swati ma'am, for the video. A work well begun is half done. Yesterday, we had a very fruitful deliberation over the challenges which are faced by legal professionals in academic field and possible solutions to overcome it. To continue further with this series of discussion, today we have with us a panel of disabled lawyers to discuss the challenges faced by them. To begin with this session, I would like to call upon Dr. Sanjay Jain, Principal, ILS Law College, to officially commence the session by his welcome speech.
Am I audible?
Yes.
Good afternoon, good evening, and good morning, because I think I have to be universal in addressing the crowd. It is really a cross-continental stellar panel we are having today. Distinguished panel of speakers, Professor, my friend Lepofsky, my friend Laura, my friend Rahul, and my friend Carol. Rungta ji, who is our senior, will join a little later because of some 11th hour issue, some meeting. And Professor ZHANG from China, who has done phenomenal work in the area of advocacy, somehow because of some urgent issue is unable to make it. But I believe we have a very stellar panel. We have a very inclusive panel, diversified panel. Discuss what role disabled lawyers can play in vindicating the rights of persons with disabilities. Honorable Director Academics and Administration, Joshi Madam, members of the Governing Council of Indian Law Society, my colleagues in the ILS Law College, student friends, other invitees, ladies and gentlemen. It gives me immense pleasure to begin the second day of this historic 3-day international summit of disabled legal professionals. And on the back of first day, I'm extremely happy because on the first day, we had the likes of Professor Michael Stein, Professor Anna Lawson, Professor Peter Blank, Professor Paul Harper, Dr. Deshpande, and two important takeaways from yesterday's summit, yesterday's panel were, and which was very ably moderated by Professor Sandra Friedman. The two takeaways were that let not others decide your capabilities. You should be the judge of your capabilities. Nothing without us, about us. And the second important takeaway of the yesterday's summit was that we have to make every possible effort to mainstream disability legal studies. Of course, if disabled alone engage in developing disabled legal studies, then it results in ghettoization. It results in bias, and you will not be taken seriously because you are playing your own game. So it was emphasized that we should also insist and urge our non-disabled colleagues to be the part of the disability legal studies movement. Today, we are going to take forward the same discussion. As has been said, lawyering is the best form of persuasion. And if a lawyer with disability appears in the court to vindicate the rights of the disabled, there is bound to be a difference. He is bound to make a difference. But I think a lawyer with disability may also make a lot of difference if he is able to vindicate the rights of his non-disabled client. Because at any rate, having himself or herself experienced the vulnerability and marginalization, he knows or she knows very clearly what are the consequences of victimization, what are the consequences of marginalization. Moreover, should disability be taken as something very negative, something which is a hindrance, or should disability be merely understood as one of the markers of diversity? Just like any other difference, disability may also be perceived as difference. And should it also be taken into account that, okay, disability-based discrimination is more often than not, it is indirect rather than direct. because the structure of our society is by and large ableist. By and large, by default, the society is constructed in an ableist manner. So how to deconstruct this ableist society? How to challenge the ableist networks of law? How to deconstruct the so-called public law, which is not public for the disabled, it is private for the disabled. Because if, as a disabled, I want to advocate for reasonable accommodation, it is said that, okay, you are a special case or you are a private case. But how can I be a special case or private case if physical and mental disability is merely one of the markers of diversity? Then individuation of law must be the part of public reason. So what Dr. Deshpande very clearly pointed out yesterday, emotive dimensions of law, politics of emotions. So what Martha Nussbaum refers to, craving of emotions, how emotions can also play a role in shaping law. So how we need to abandon the linear approach to law and how we should adapt to multilinear approach to law, right? All these issues will be hopefully discussed. I thank organizers for giving me the opportunity to speak to my mind. And I wish that we will have very interesting ideas to play with during this amazing session of stellar panel. Thank you very much.
Thank you, sir, for paving out the right path for further discussion at this session. I would now like to request Advocate Rahul Bajaj to throw some light upon the theme for this session. Rahul, please, I would like to request you to please shift a little bit ahead in front of your screen.
All right. Is this better?
Yeah.
Okay. Sorry about that. Hi, everyone. My name is Rahul Bajaj. I'm very excited to be here and to be moderating this session here today. Let me say a little bit about myself before introducing our panelists and the theme and structure of the conversation that we're going to have today. I am a 26-year-old lawyer from Nagpur in the central part of India. I pursued my legal education at the University of Nagpur. I graduated in 2017. Worked at a law firm called Trilegal for a year, then went to Oxford for my postgraduate education, and I'm currently clerking at the Supreme Court for Justice Levi Chandrachud. I also happen to be blind since birth. I mentioned this only given the nature of the conversation that we are having. I think it's important to put this out there. In terms of what we hope to discuss here today in the course of this conversation, it's essentially, we've given each of our speakers a set of prompts that hopefully they will stick to in the remarks that they give. I would be happy to reiterate those if they would like me to before they start speaking. But the idea would be, will be to acquire a wholesome appreciation of the kinds of challenges that they have had to face as lawyers, as litigating practitioners, on account of their disability, what strategies they have deployed to address those challenges, what challenges they have found insurmountable, and also more broadly, how we can create in society, a more enlightened consciousness, and especially not generally in society, but specifically in the context of the legal profession here, about the capabilities of persons with disabilities. So that's the whole idea behind having this particular session. Let me then introduce the four speakers that we have with some brief remarks about each of them. Professor Jain has already mentioned the four speakers that we have are Mr. Rungta, Laura, Wolk, David Lepofsky, and Carol Taylor. Allow me to just briefly introduce each of them. So Mr. Rungta, I guess, okay, I will introduce him now, even though he will join us a little later. He became a senior advocate at the Delhi High Court in 2011. He's blind since birth himself and has really been a way paver and path marker for persons with disabilities in India generally, and especially for those of us in the law. He has argued many cases before the Indian Supreme Court. He's also been at the forefront of the fight for equality and dignity waged by the disabled. It is his interventions that have, for instance, resulted in the blind being able to join the civil service in India, being able to serve as witnesses, the capacity of the blind to make wills being affirmed by the court, and them being granted reservation, which is essentially an affirmative action quota for those of our friends in India, set out under the Persons with Disabilities, the erstwhile Act of 1995. He was also spearheaded. He was also a critical part of the deliberative process that resulted in the framing of this new law that we have now have in 2016. Our second speaker is Laura Wolk. Laura did her JD at the University of Notre Dame, where she graduated in 2016, summa cum laude. She received the prize for outstanding achievement in the program of public law at Notre Dame. Since then, she's had a fairly diverse and distinguished, I'd say, for someone this early in the profession career, having done 3 clerkships. First for Judge Janice Rogers Brown on the DC Circuit Court of Appeal, then for Judge Thomas M. Hardiman on the 3rd Circuit. Then she worked at the Supreme Court and Appellate Litigation Practice at Kirkland and Ellis for a year, and finally clerked for Justice Kevin Thomas at the U.S. Supreme Court last year. And now she's back into sort of private litigation practice. Our third speaker is Mr. David Lepofsky. David he completed his legal education at the University of Osgood Law School in 1979, and did the LLM at Harvard, which he completed in 1982. He then worked from 1982 until 2015 for the Ontario Ministry of Attorney General. He argued 30 cases before the Canadian Supreme Court. He has thus far argued 30 cases before the Canadian Supreme Court and more than 200 cases before the Ontario Court of Appeal. So he's a distinguished appellate litigator, and he happens to be blind. All these 3 panelists happen to be blind. I given the comment, I think it's important to mention that. And then let me finally introduce our 4th and final speaker, Carol Taylor, who was admitted to the Supreme Court of New South Wales in 1993. She has extensive experience in family law, migration law, wills and estates, and as well as in commercial law. She started her private practice in 1998, and she then later went on to found Carol Taylor and Conveyancing, which works on property law and estate matters. So that having been done, now I would like to invite each of us, so just in terms of structure, a word on how we will go from here. It's 6:27 p.m. where we are in India, so we will hear from each of our panelists for about 45 to 50 minutes now. So we'll give each of them around 12 minutes to speak. Till around 7:15, we will hear their remarks. Then I will ask them some questions for around 20-25 minutes. And then the last part of our conversation, the last 15-20 minutes, will be devoted to answering questions from the audience. With that, Laura, can I invite you to first share your remarks with us? Laura?
Hi, can you hear me now?
Yes, I can.
Okay, sorry about that. Well, thank you very much for the opportunity to speak with everyone. For me, it's morning, so I will wish everyone a good morning, afternoon, and evening. And Rahul, I really appreciate you asking me to participate in this, because I think it is really important not only to talk about our own experience, but to hear what other folks with disabilities experience in their lives. So, as Rahul said, I recently finished a clerkship at the Supreme Court of the United States, which in our system is the top court of the federal system, and it also reviews cases from state courts as well. So it's really, to say it objectively, it is a wonderful position for a young lawyer to have, and it's a position that a lot of people most people will never get to experience that type of relationship with our government and to see how the judicial system works. So I was very blessed and privileged to be a part of that, especially as one of the only blind people who, I'm the second blind person to clerk there, but the first person, it had been some time, it had been about, I think, 12 years or so since the first blind clerk had been at the court. So you can imagine a lot of technological change happens from 2008 to 2020, and also a lot of institutional knowledge is lost when you only have a person with a disability there every 10 to 15 years. So it was, in some ways, in almost every way, it was a very rewarding experience. But it did once again remind me that as a person with a disability, when you're entering into certain areas of the law, you are always, you're going to be the one who's not only the one who's trying to get all the work done, but you're also going to be the ambassador for other folks with disabilities who you hope to come after you. So I just want to use my time here to speak on a few topics. The first is, as Rahul mentioned, I only graduated in 2016. So in the grand scheme of lawyer land, I'm still quite a new lawyer. And I've also had 4 different jobs in that time because I worked for 3 different judges, and then now I'm at the firm. So I've had quite a lot of experience moving from place to place and having to navigate what it's like to enter a new work environment that where most people have never interacted with a blind person before. And I readily admit that everyone's strategies are different, and so the strategies that I employ as to how to get myself taken seriously and part of the team might not be for everyone, and some people might vehemently disagree with some of the approaches I've taken, and that's fine. I think I really, as I get older, I really have begun to believe that there is no one-size-fits-all solution for everyone, and we all just have to do what we are comfortable doing in the moment to get ourselves taken seriously. So my approach has been to really concertedly seek out allies. I have, I mean, to use the term that is in modern usage, I would say friends or mentors. But ever since I entered, actually before I entered into law school, my understanding was that I was not going to be able to succeed and do what I needed to do at this point in our history without very serious, strong support from people who are not disabled, or at least that are sighted. And my thinking behind that was that things being what they are, there are going to be questions that people have that for legal reasons or even just social pressure reasons, they don't want to ask me directly. And I would rather, though this is not an ideal situation, I would rather have it be the case that those questions can be answered and those fears can be assuaged, rather than them never being asked and perhaps the stereotype or the assumption being that I'm not capable. So I spent a lot of time and a lot of energy cultivating relationships with professors, with friends who were also in the legal profession, for creating this network. And again, not just for purely utilitarian reasons of wanting to get a job, but it's also just good for your life to have a broad network of friends and colleagues and mentors. And that way, in doing that, when it came time to apply for clerkships with judges, I knew that the judges, if they so desired, could reach out and speak to people who were not me and say, she worked for you, how was her work product, or how did this work, or can she do track changes, can she do these things that maybe they don't feel comfortable asking me. And the other, that's one broad approach, and I would say the other approach that I have adopted over time is to be very blunt and direct when I start a new job and begin working with a new partner. One of the struggles at a place like Kirkland is it's an extremely huge firm. So you could be working with a different partner on a variety of different, you could have 6 cases and you're working with 6 different partners, which means that each time you have to go through the same process of educating them until everybody knows what you need. One of the hardest things for me has been stating without apology and objectively what I need or what is a problem that is being caused by my technology. So instead of saying, I'm really sorry, but it would be helpful if you could send this to me in a Word document, to take that and instead say, now that I'm on your team, it's important that people know that all documents have to be sent as Word files for accessibility reasons. And that's very uncomfortable as a new lawyer. And I oftentimes would recruit friends. I would send emails to friends, particularly male friends, for any of the women listening. I think this is something, again, where gender can play a role, where we tend to want to downplay things, and through socializing, we want to downplay things and minimize our needs. So I would send emails to friends and have them be like, nope, like if I were asking for something that was totally reasonable, I would not phrase it this way, I would say it this way. And learning from them and taking that advice, so that when these emails are received, it's very clear from the beginning that, number one, the things that I'm asking for are reasonable, but more important, when something does come up that is a technological issue, it's not my problem. And it's not something that is tied to my merit as a lawyer. It's something that's tied to a technological problem. And so, just getting comfortable saying things like, just the other day, I got a case, and I was sent a massive tome of PDF files that had not been OCR'd. And I wrote back to the partner, and I was just able to say, just so you're aware, none of these files are accessible. It will take me some time to convert them into a format that I can use. I will need your assistant to help me to do that, so that I can get this done in a more timely fashion. And like I said, I don't want to downplay. It is a very uncomfortable, for me, it's been an uncomfortable way of learning to be assertive. But I have found that doing that in conjunction with having a wonderful network of people, they feed into one another. So you do that with one or two partners and you earn their respect, and then you do the work product and they know that you can do it. So then the next time, if a partner reaches out and says, hey, I need someone, do you know anyone who has some time on their hands? The partner who's already worked with you can say, you need to work, you should work with Laura, but by the way, just so you know, when you interact with her, these are things that help her to work faster and that are more accessible. So by doing it that way, you create this like feeler system of people who can then take on the part of the work for you of carrying that load and just doing part of the educating for you and doing part of the the hard work of getting people to take you seriously. And I think this does touch on another topic, which is the exhaustion that a lawyer can feel. That it is a lot, and you never stop advocating, and you're constantly in the position, whether it's a new client or a new partner, of getting people to take you seriously as a blind person. And I think that by doing the hard work in the beginning of cultivating a network, that whether it's, like I just described, a partner being the one to say, use Word, this is how you tag a PDF. It's important to tell Laura when you're CCing other people on an email because she might not otherwise notice all these things. They're doing some of that work for you. And then on top of that, when things do go wrong and you're having technology problems or some other issue that you can't control, you have those ears to listen, and you have people that you can vent freely to without the fear of them thinking, oh goodness, maybe this is all just too much, and I shouldn't be working with her. Now, all that being said, I do realize that I'm, not every professional setting is the same. I'm very fortunate. I also, we do have legal protections in place that people are largely aware of, so that even when you don't have super understanding people, I do have the luxury of having the backstop of the ADA and other laws that do protect me. And I realize that gives me freedom that not everyone has, depending on the laws in their country or the system of their country. But those are my experiences, and I do think that partially through creating a community like through this conference, that we will be able to trade tips and tricks and just be there for each other when that exhaustion, or when we've taken that leap of faith, with a partner and or a supervisor, and it hasn't worked out so well for us. So those are what I'd like to share as an introductory matter, and I look forward to everyone's questions.
Rahul, you have been muted, so please unmute yourself because you are not audible.
Hello?
Not yet. Yeah, now. Yeah.
Sorry, it took me a while to get to that other screen.
Yes.
Thanks very much, Laura. It was very nice to hear you offer a clear-eyed, pragmatic perspective, in terms of just putting it as it is rather than trying to make it appear rosy or more hunky-dory than they actually are. So we really appreciate that, and I'm sure it really what I've just said. Let me now call on David Lepofsky to share his remarks. David?
Morning, everyone, from beautiful Toronto, Canada. It is an incredible and humbling honor to be part of this. I want to cast you back 44 years ago when a much younger me was sitting down, or just around this time of year, to write my very first law exam in first year. I'm totally blind. I'm sitting in front of this ancient device called a typewriter. I'm typing madly for about 20 minutes on my criminal law exam when I realized that the ribbon had broken. What that means, for those of you who don't know what typewriters are or how they work, it meant that I had been typing and the pages I was producing were beautiful but blank. Nothing had been transcribed. This is not the way you want to start your career of writing law exams. I was able, thankfully, to get a new ribbon installed. Thankfully, I found out after only 20 minutes, and I wrote like crazy, caught up, and got the exam done, and it turned out to be an A, which led me to think that the more my ribbons break, maybe the better I'll do. The challenges that I have faced as a blind person practicing law after completing law school for 33 years before I retired from working for the Ontario government in the areas of civil and then constitutional and then criminal appeal law, the way I've tackled them have evolved very much like the way public transit has evolved from when our great-grandparents used a horse and carriage to get around, to the way in Star Trek they travel at warp speed, faster than the speed of light. Somebody's typing and they're not muted, and I just want to ask if they might want to mute themselves just so that that doesn't affect people. Thanks very much. In any event, I don't want to talk about my specific practice strategies because they evolved so often with technology, from human being readers to towards the end preparing a murder case when I was at the dentist, and I wanted to get every last minute of time in preparing, and simply while the dentist is working in my mouth, having earphones in my iPhone is playing a murder trial transcript to me. From being able to have to sit up at night transcribing notes into Braille for hours, to being able to walk in with a laptop with everything written down on it so that I just put an earphone in my ear. The transformation was spectacular in my career. What I'd like to do instead is to focus you just for a few minutes on what I've been doing since I retired and what I was doing before I retired, all part-time, now it's full-time, in a volunteer capacity, because I've taken those skills I used in the courtroom and transformed into a volunteer practice as a community organizer and community advocate on disability accessibility issues here in Ontario and in Canada. I'm not acting as counsel. I'm not, in fact, acting as a lawyer. I'm a community, I lead a coalition, the Accessibility for Ontarians with Disabilities Act Alliance. But I've actually been finding that in this lay role, I'm taking all the skills that I learned as a lawyer, the skills in writing, in organizing, in formulating strategy, how to frame an argument orally, indeed even how to question people at a meeting, that I learned in the courtroom. And to that extent, I had to also draw on the skills that as a blind person I had to learn to use in a courtroom, how to size up how people are reacting when I can't see their faces. I've had the privilege, just to take you in my short time on a quick tour, I began 40 years ago this fall, when Canada's Constitution did not then include a Charter of Rights, and our Parliament was debating whether to include one. It was proposed to include an equality rights clause, but it wasn't going to include disability. A number of us, including me as a young law student, had the opportunity to appear before our Parliament. I did it 40 years ago plus 10 days, December 12th in 1980, and the video of that is now up on YouTube. I'm told I look different because I had hair back then. To argue, and we were all collectively successful in winning the Constitution, the disability amendment to our Charter of Rights. I was able, over a decade later, to take part in and then eventually lead a decade-long campaign to win the enactment of our counterpart to the Americans with Disabilities Act, the Accessibility for Ontarians with Disabilities Act, and I now lead the coalition called the AODA Alliance that campaigns to get it effectively implemented. The blog will include key links to give you more background information, but if you want to learn about what we've been up to and see our strategies, you can go to aodaalliance.org. Now I'm involved very actively. Since then, I've been involved with many others in campaigning to win last year the successful enactment of the Accessible Canada Act, our federal counterpart to our provincial legislation. But what the message I really want to bring home to you is, just as over my career as a practicing lawyer, I evolved my strategies from typewriters to iPhones, from human being readers to screen readers. And just as the challenges changed from print documents that were inaccessible to PDFs that are inaccessible, and having to learn to react to them, I've also learned how to harness different strategies in my community organizing. Let me just give you a few examples. One of the things you learn as a lawyer in a courtroom is how to frame your argument, your case's position, in a way that will most compellingly express your case and most persuasively disarm your opponent. We've done that in our accessibility movement. The old way of talking about these things was discrimination, and I agree that inaccessibility is discrimination. We instead talk about barriers and the obligation to achieve a barrier-free society. The beauty of the word barrier is it doesn't alienate the left or the right. The left thinks barriers are unjust. The right thinks they're inefficient. They all hate barriers. Even businesses hate them because they impede them from getting access to clients and customers. We learn to not talk about people with disabilities as a minority. I have a kind of a blind gig or trick I do when I'm speaking to audiences. I ask people I say, I want to know if you're part of our movement. Raise your hand if you don't have a disability now, and if you know you'll never get one in the rest of your life. I then turn my head as if I'm looking around the room, and I go, I don't see any hands. And everybody laughs or chuckles because it's kind of a blind joke. But I then declare, we are the minority of everyone. By redefining disability inclusion as the minority of everyone, we've now turned ourselves from a minority, we can't afford you right now, to the majority, to everyone, and therefore strengthen our case. We've also learned how to use evolving and different technologies. If you want to get our updates to learn our strategies, you either go to our website or you write me at aodafeedback@gmail.com and just say, sign me up, aodafeedback@gmail.com, or follow me on Twitter at David Lepofsky. Lepofsky is Lepofsky. But what we've learned is to go beyond even those traditional things. We use Twitter very actively, so much so that I've had public servants call me and say, can you please not tweet about this Friday afternoon because we want to go home for the weekend. I consider that the supreme compliment, or a politician who kind of groans and says, you folks sure tweet at us a lot, with a bit of an edge in their voice, but also a pat on the shoulder with a keep it up. But the other thing that we've learned is that we keep reinventing our strategies. I'm just going to give you one or two. One of the things, we wanted to point out the fact that buildings are repeatedly still designed to be inaccessible. And that's, even though the myth is that we only used to do that in the old days before we knew better, but now we know better. We found that architects are doing a worse job now than they used to before. And how do you point that out? Well, you can write briefs and you can make speeches. We did that. But I decided one day to take my iPhone into a building that was emblematic of how this is bad, a brand new university building. I got a friend to help me and we shot a video. It's up on YouTube. It's had thousands of views. It's gotten media coverage. It's been used in different countries. And it's being used to train architects. It depicts the barriers in a building which turns out to have been awarded architectural awards. And it's a blind guy narrating it. I had sighted assistants, of course, putting this thing together, God knows. But coming up with the use of a free site like YouTube and the creation of a video, it borrowed on the same skills I used when I wrote a brief, or what we in Canada call a factum for court. In fact, I worked on the text of our script, checking it the way I check the facts when I would appear in the Court of Appeal of the Supreme Court of Canada in a brief that I'm writing. And bringing this up to the most recent, and with this I'll turn to my conclusion, but the most recent cause we've been very actively involved in is battling the barriers that people with disabilities, the additional hardships during the COVID crisis. And so one of the new resources that we're using is I've been able to get a number of lectures I've given posted online, captioned and available for anyone to see anywhere around the world. If you just search on my name on YouTube, or you go to our website, you'll see links to all of these, including a lecture just posted a few days ago on our battle during COVID. But one of the battles that we've been facing is the fact that with hospitals being overwhelmed, and this is an issue in your countries as well as ours, with hospitals being overrun with COVID, there's a risk that there won't be enough critical care beds, that there may be triage or rationing of life-saving medical care. And in my country, that medical care is guaranteed. It's insured through public health insurance. Well, how's it going to be done? We have a serious documented fear that it could be based on discrimination, based on a patient's disability in some circumstances. So a bunch of us did some advocacy on this. We've made some progress, but not enough. But you can go online and see a lecture I gave at my law school documenting this history that we're now tweeting to journalists and politicians. And you can also see a presentation I made to the government's own advisors on bioethics, on what the standard should be, so they can know what our pitch is. This is all available through our website at aodaalliance.org/COVID. Let me conclude with an ask for anyone watching, including in case anyone from yesterday's program is watching. I'm now a part-time professor, visiting professor at the Osgoode Hall Law School here in Toronto. And one of my jobs is to write a report for my faculty on ways to better include disability rights in the curriculum of the law school. Both what should be included and what strategy is most likely to get it actually included in what's taught in the classroom. I welcome any of you, the ideas from any of you. Write me at aodafeedback@gmail.com. aodafeedback@gmail.com. And I encourage you to let me know your ideas. The blog will include links to various of the resources, the videos that I've talked about during this talk. Let me conclude by paraphrasing what I said to the Parliament of Canada 40 years ago plus 10 days, when I was arguing with others to get disability included into our Charter of Rights. A number of us combined to win that. I said in conclusion there, and I say today, that it is a cliche or an aphorism that justice is blind. And yet, for us, it's important not only that justice have the opportunity to experience blindness, but that blind people and all people with disabilities equally have the opportunity to experience justice. Thank you very much for including me, and I look forward to hearing my fellow panelists and to your questions.
Thank you so much, David, for such a wonderful, power-packed address. And I guess your remarks also point to the ways in which the skills that you learn as a lawyer with a disability have helped you do the work that you've done since retirement, the pragmatic approach that you've deployed to push for inclusion in new and innovative ways, and how the problem solving skills and creativity that one is required to develop as a result of one's disability, how that can get spent in certain circumstances. Let me now call on Carol to share her remarks.
Good evening, everyone, or good morning, or good afternoon. I hope you can all hear me. I would just like to say, first of all, thank you for inviting me to participate in this event, and I feel very humbled and honored to be invited to participate, and I find myself amongst some very esteemed company here, so I feel very honored indeed. As was mentioned earlier, I studied at Sydney University in Australia, and I was admitted to the Supreme Court of New South Wales in 1993. In 1998, I established my own practice, and it was largely in the areas of commercial litigation and family law and immigration law. So that meant for me that these practice areas meant that much of my working life was spent in a courtroom. Now, in 2001, my husband and I was a newlywed at the time, my husband and I were coming home from a weekend away in the Blue Mountains when we hit black ice early in the morning, and the car rolled, and on the second roll, the roof caved in, hit me on the back of the neck, and instantly severed my spinal cord. In that split second, my life was forever changed. I was left a quadriplegic. I am paralyzed completely from the chest down, and my hands and fingers are also completely paralyzed. I was airlifted to hospital and placed on life support and spent the better part of a year in hospital. But what followed was without doubt the hardest 4 years of my life, where I came to terms with my life post-injury, this catastrophic injury, and getting used to my new body, and acute post-traumatic stress disorder, depression, and the end of my legal career, or so I thought. So then it's impossible for me to encapsulate what it was like to come to terms with this. It's taken me 2 decades. However, in 2006, I should say that my husband and I were blessed with a son post-injury, and we moved to sunny Queensland, which I believe at the moment is probably one of the safest places on the planet, for which I'm very grateful, given that 60% of my lungs are paralyzed. So here I am, roll forward 8 years from there, and I have now an 8-year-old son who has increasing independence, and I really start to miss my sense of professional identity. And I voiced this to my husband, and with his encouragement, I decided to apply to the Queensland Law Society to reinstate my practicing certificate. Now, having experienced a 14-year absence from the Law Society were not about to give me a practicing certificate and let me loose on an unsuspecting public. And it was quite right and proper that they require me to undertake a course of study, a practice management course, which would typically involve reading materials, studying the material, and sitting a written exam. At that time, for me, even just turning the page to read the material was something that I wasn't able to do. I had to adapt, believe it of all things, a rubber thimble, which gave me the ability to just push the page out of my way and turn the pages. I find it very, very hard to work off of a screen. Even now, I still find it very difficult to work from a screen. And I knew that sitting the written exam was going to be a problem. Fortunately for me, the Queensland Law Society were very supportive, and they agreed that I would sit my exams orally. This was quite a challenge, as it also included a 5-hour oral trust account exam, which was rather horrendous, but I did very well at it, and obviously it was something that we needed to make sure I was going to return to practice and I could handle as well. Now, not being able to sign a document for me was quite devastating. I can vividly recall, whilst I was in hospital, there was an election in New South Wales, and the time came to vote, and we were all brought in to sign the ballots, and I had to give instructions to someone else to put an X where my signature was to go in order to vote. And that was one of those life-defining moments where I having signed so many legal papers in my career, that I felt I was reduced to this. I found it very flattening. It really was very hard for me to pick myself up. I felt worthless, and I was determined to write again. Now, I'm much stronger now, and with the help of a very strong right shoulder, I managed to balance a texter pen on paper and glide it across the page with my shoulder to sign. I can take a very small amount of notes, but certainly nothing substantial. So I finally had my practicing certificate, and now I was faced with the question of what am I going to do with it? So I looked around for a mentor, and I didn't know anyone else like me. So arrangements were made for me to meet with a female lawyer to discuss my options. Now, unfortunately, this colleague did not turn up to our planned meeting. I was left waiting. I waited for over an hour, and this woman was a no-show. I didn't receive an email, text message, anything like this. I called her office, and I was informed that she was busy. This was one of those defining moments for me where I experienced a crisis of confidence. I honestly thought about giving up. I'd worked so hard to get my practicing certificate. As part of the studies to obtain it, I had a major panic attack in the middle of a shopping centre. It was extremely difficult for me to overcome and get this little piece of paper. And this woman did not consider me worthy enough to meet me and have this planned chat to discuss what my options might be. And I felt that I'd shake off the feeling that this would never happen. This wouldn't have happened if I was an able-bodied person. And as I said, I didn't know anyone else like me, and I really felt deflated, and that formed the view that the only job that I was going to be capable of getting was that of a doorstop. I was quite devastated. I thought nobody's going to want me because I've got nothing to offer. Now, it was at this time that my husband suggested, well, look, after I dried up the tears and pulled myself together, it's like, why don't you consider establishing your own law firm like you did previously? Now, at this point, I think my deep sense of grief and disappointment in myself had turned to anger at this colleague not meeting with me to give me the time of day. And that anger fueled my determination to succeed. About this time, my husband told me about a new form of technology that would revolutionize the way in which property transfer was undertaken in most of Australia. Most states have mandated it now. This was the catalyst to my returning to work. I had a light bulb moment where I could see how it would be possible for me to run a legal practice from my mobile office, or what I call my mobile office, in my wheelchair. So in 2015, I established Taylor Law and Conveyancing, and we became pioneers in the field of electronic conveyancing, which mightn't sound very exciting, and certainly not the most riveting area of practice, but it gave me a sense of purpose, and I'm good at it. I read the contracts well, I advise my clients well, and it's allowed me to reconnect with that sense of professionalism that I had pre-injury. So I might also add that this technology, as I said, was a catalyst to my return to work. I really grabbed it with both paralyzed hands and ran with it. And I had the great honor of my little practice, it's only a small practice, becoming the very first law firm in the state of Queensland to complete a simultaneous electronic online settlement between two properties that were 1,200 kilometres apart. And at the time, less than 1% of all property transactions were completed electronically. But now 90% of my matters that in my practice are completed electronically. I can very vividly recall the very first day that my assistant brought me the adapted phone. We had to adapt everything in the office so that I could use it. Brought me the adapted phone to take the first call from my first client inquiry. And I know from the way she's described it so many times that the colour just literally drained from my face. I was paralyzed, but this time I was paralyzed with fear. But with the support of those around me, I accepted that first call, and I've never looked back. And before I knew it, we were building a separate building on our 10-acre property to accommodate our small team. And my practice was in full swing, doing what I call wheelchair-friendly law, property transfers, wills, powers of attorney, and probate matters. So now I answer, how did I do it, and what challenges did I overcome? Obviously, one of the biggest challenges someone in my situation, and anyone with a disability, is going to have to overcome at some point, is discrimination, prejudice. Generally, there is the presupposition that we don't quite live up to task. We're not quite up to it. You know, I think in the criminal justice system, you're innocent till proven guilty, but when you're a lawyer with a disability, you bear the burden of proof to prove that at minimum you're equal to your able-bodied counterpart, and that your disability is not going to be an obstacle to success. Now, I would argue, rather arrogantly some might say, I would argue now that I'm a better lawyer post-injury than I was prior to my injury, because my lived experience of disability enables me to bring a level of empathy to the table that I didn't previously realise that I was lacking. You can't miss what you've never had. And this increased awareness and empathy to my clients' needs is something that my clients reap the benefit of. They reap the benefit of this change in me, and they're loyal to me because of it, and they're my best source of referral work. I don't have to do a lot of advertising. There have been occasions when I felt dismissed or underestimated by members of my own profession, and even the odd client. And I would say what's required in answer to that is good old-fashioned grit. You know, by majority, the response from my colleagues and clients has been positive, but you're not going to win them all. And that used to wound me. That used to wound me terribly in the early years, but I'm well past worrying about that now. You know, I was very much a bit of a shy wallflower to begin with, I suppose, and now I don't put up with that nonsense. If someone doesn't want me, they can't see the benefit of having me in their corner. I don't take it to heart. I'm not going to win them all, and I accept that, and people have a right to their own position, I suppose. So, secondly, I would say that the other obvious challenge that I have to overcome is the built physical environment. That presents challenges for anyone with a disability, and I constantly take every opportunity to beat the drum about the importance of embracing inclusive design. In 2017, missing the action of the courtroom, I suppose, I allowed myself to be lured into taking on a family law matter for a friend, an able-bodied friend and a paying client. I ran the matter for 2 years. We went to court and obtained a successful outcome. My client was very happy. I have to say that I'm fortunate in Australia that the Federal Circuit Court catered for my needs in a wheelchair very well. However, I can say that my disability is, at some point, I had to step back and review the situation. As I mentioned, I endured 8 years to achieve a family, and this family law matter, with all that it involved, preparation of subpoenas and affidavits, and it kept me from my young son. And for me, work-life balance is paramount. And so I accepted that I accepted that I can't be Wonder Woman, and something has to give. And in this regard, I'm no different to any able-bodied working mum. So I made the decision to narrow the focus of my practice to exclude court work from now on. So I've come to the conclusion that some people will respect you for what you do. Others will dismiss you. But what's most important is that we remain true to ourselves and refuse to be discounted as lesser than victims of disability. It's a mistake, I believe, a big mistake for any organisation to devalue or underestimate what someone with a disability can bring to their organisation, whether it be a law firm or a courtroom, albeit with some reasonable adjustments may be required. And I would say that one of the other challenges, the final challenge I'll touch on this evening, is imposter syndrome. There have been many cases where I am my own worst enemy, where I'm plagued with doubt, self-doubt, and even coming here this evening, for me, I wondered, looking at the list of esteemed presenters, speakers, advocates, and lawyers here, wondering what on earth am I doing amongst you all. So on that note, I'd like to share with you a video that I hope Professor Sanjay is going to assist me with, as I am not familiar with Meet Google. I have spoken to Professor ZHANG, and I believe that he's going to cue this little video for me. For those of you that are visually impaired, I would like to explain that I am a white woman with blonde hair and blue eyes. I am seated in a powered wheelchair. I'm wearing a blue aqua top, which is one of my own designs, and I can be seen speaking with my assistant and my husband Robert, who is also my practice manager. Thank you very much.
Thank you. Thank you. Wonderful. My colleague will assist in playing the video.
We request all the participants to wait for a minute before the technical arrangements are getting done.
My name is Carol Taylor. I am a solicitor and property lawyer, and I'm the principal of Taylor Law and Conveyancing on the Gold Coast. I moved to Queensland because I had sustained a catastrophic spinal cord injury, which ended my practice, and I moved here in 2005. PEXA was the catalyst to my returning to work. So I grabbed it with both hands. And I knew it was going to be something amazing, and it was going to enable and give me so much freedom and give me my career back. My working life is very different now than what it was in Sydney. I have a very different practice style. My working life in Sydney was very corporate, it was very old school. The PEXA revolution has given me so much independence to run my practice the way I see fit now, so it's given me a lot of work-life balance, obviously a lot more relaxed in the way that we approach our work. Art has been a very, very important part of my life, and it's been a form of therapy, which has then reaped the benefit of giving me the confidence to return to the law. PEXA has just saved so much time, particularly with staff. They're not waiting on hold to book banks, to make sure that all the other parties involved can arrange a settlement at a convenient time to suit everybody. It's a huge drain on staff time. I use PEXA to benefit our clients. We can do a settlement and have cleared funds same day to our clients, in some cases within 20 minutes of settlement. That's unheard of. My advice to anyone considering the move to digital conveyancing is just do it. Don't think about it. The benefits are just ridiculously in your favour.
Thank you, Carol. Brilliant.
Thank you very much, Professor.
Love you. Brilliant.
I am loath to using the word inspiring to describe someone with a disability, but one cannot help but be moved by learning about all the struggles that you had to undergo because of your injury and how you were able to pick yourself up and really build your career from scratch after that, and now attain distinction in the workplace. Thanks very much for sharing your journey with us.
Thank you so much for inviting me and allowing me to share my story.
It's pleasure is ours.
Is Mr. Rungta here?
No, unfortunately, Rahul has not yet joined. So I think we can start the question answers, and you can start Q&A. If he joins, we can ask him to speak.
Yes, that's what I was thinking. So it's 7:15, so we will start and then get back to it. All right. So I have a set of questions, a few general questions for everyone, and then a few specific questions for each of you that is put to you. First, let me get to the general question. So the first one that I have is about what I regard as the difference between the Friday evening view of accessibility versus the Monday morning view of accessibility. And what I mean by that is that a lot of employers in the legal profession, clients, etc., when asked in the abstract if they are open to having a lawyer with a disability work for them, will embrace the idea and extol the virtues of diversity. But when it comes to the cut and thrust of everyday work and being able to provide deliverables within the required time span, people have a low tolerance level, and their patience begins to run out, because of which a lot of lawyers with disabilities are unable to realize their full potential. How, according to you, can this challenge be countered? Who would like to go first?
I can go first, Rahul.
Sure.
This is Laura. So I think part of the problem is that, and I loved what Carol, when you phrased it that way, that the burden of proof is always on the person with the disability, I was like, oh my goodness, I've been struggling to put that into words forever. So thank you. But I think part of the problem actually is that you're expected to be the expert at everything and to have a solution for all of the things that can come up along the way, even though you have never experienced a situation before or perhaps had to interact with the technology yourself. And that has happened to me numerous times where it'll be a task. I'm still a new lawyer. They'll be like, you have to do this. And I'm like, well, what does that entail? And as they begin explaining, I'm like, oh, man, I need to do some research and think about how I will do this as a person who is blind, and there's no one at the firm or at the wherever I am who has any ideas because they haven't done any accessibility research whatsoever. Again, I can only offer my own thoughts. One of the things that I have found is very helpful, especially if you have lead time when you're beginning your job, is to make it very clear from the beginning that you are not, even if this is the case, I think it's a valid thing to say, that you are only an expert in being a lawyer. You are not, do not have a degree in accessibility, you don't have a degree in assistive technology, you don't have a degree in any of these other specialized areas. And so it is not a valid approach to ask me to have the solution to all of these problems. And so like one of the things that I say when I begin a job is that it's very important. I understand if you have never had a blind person before, but it's very important in this time leading up to me onboarding that your IT staff educate itself about the technology I use, because I'm not going to be available to do that, or for the people that you're working with, that it's important for HR to be doing some of the educating here on accessibility. I've had varying degrees of success with that, but I think that the most important part is making it very clear up front that, I'm not an expert. And to give one example, and again, I recognize that this is this strategy isn't for everyone. And that it can be a little risky, and there are certain freedoms that I have in terms of where I feel that I'm able to take greater risks. But to give it an example of this, I found out suddenly that the place that I was working at the time had a required training. It was a required trial advocacy training, and I was sent this binder of printed materials. And I was like, you need to book a plane ticket and go to this place where the training is. And I refused. I just said, I'm not participating in this training. No one has done any work to make this accessible, or to do trial exhibits, or to do document presentation in a way that I would ever do. And if I participate in this training, it will just be me trying to muddle through to get through the week, to do things your way. And that's not how I would do it as a blind lawyer. It's a waste of my time, and I'm not doing it. And it was not the most comfortable thing in the world to do, but I didn't do the training. And I was like, well, try again when you take my needs seriously. And they came back and said, well, what do you need as a trial lawyer? And I said, I don't know. I'm part of the reason that I'm a new lawyer is that I'm figuring out what I need as a trial lawyer. And so you can't just send me an agenda and say, these are the things that we're going to be covering. You figure it out with a week in advance. So anyway, I guess that's not really a great answer to your question, except to say that my default position is always to, even if you are faking it till you make it with that confidence, which I have done many, 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 many times, that you come at it with this place of assertiveness and repeating ad nauseum as much as you can that these are issues that cannot be fully placed on the shoulders of the person with the disability to solve, because we are just human beings who have disabilities. We do not have all of these expert credentials that people assume that we have.
Hi, it's David. Would you like me to follow up? Okay. Laura has provided a superb description of how these things can arise and some of the horrible positions you can be put in if they do arise. Let me just offer a few other thoughts. The first is that when these kind of things happen, whether it's a technical breakdown or whatever, it's important to be ready to put it back in a context, which is, it's true, some people may assume that this is all, disability related for us. Some may assume that. And I'm quick to try to turn that around and say, anybody else ever had a computer problem? Or anybody else ever had materials delivered when you don't have time to read them? And of course, everybody else has. Everybody's had it. So I then framed the problem we have in terms that it's actually the problem everybody else has had in some form or other, to try to at least get them to understand us in that context, that it's not, oh my God, if you hire blind people, this is what will happen or whatever. And I've been fortunate that that's been reasonably successful. The second strategy is, and this is not a total answer to the concerns that Laura raised, but I always believe in building redundancy in backups. So, for example, the standard operating procedure in governments and private sectors, they give you a computer, and then after 3 years, they replace it, you give back your old computer. Well, I have built in an insistence that I keep my old computer. And I keep it loaded with as much of my data as I can, whether it's shared via Dropbox or whatever, because I know that for a person who is sighted, if their computer goes down, they can just go use the next computer at the next workstation. We can't. So I need to be able to always either reach into a drawer or slide over to the next laptop over, which is my old clunker from 4 years ago, but it still works. I actually had a case where I was in the Supreme Court of Canada and my computer was particularly giving me trouble, so I made a point of bringing my redundant computer to court. And my laptop, my current one, actually crashed on me about 10 minutes before I was going to argue while somebody else was arguing. So I had a momentary gasp, and then I reached into my briefcase and pulled out the backup computer, booted it, and went on. And the third and final thing I'm going to suggest, which is not at all responsive to what Laura was saying, and maybe not responsive to your question, but heck, let me try it anyway. We also have to be ready to push our envelopes, which we do all the time, in a way that helps change the channel on what you're talking about. And I've been very fortunate in my career. My office was very supportive of my work, but perhaps the best illustration of it is that the last case I ever argued in the Supreme Court of Canada before I retired, and in another case, the last case I argued in the Ontario Court of Appeal, were both eyewitness identification evidence appeals. Now, let me say that again. They were both eyewitness identification evidence appeals. Now, if you had asked me way at the start of my career if there's one kind of case that I probably couldn't argue, it would be an eyewitness identification case. But I figured a way around it, and it worked. And I think, yeah, we were successful in both appeals, as I think about it. And so I had to overcome my own sense of, hey, maybe this is something which wouldn't work. And it did. So anyway, back to you.
Actually, Rahul, can I just quickly follow up with one thing? I just want to say, so David, yeah, I could not agree with you more. This is actually something in terms of reframing things, in terms of what things that people understand. One of, I was a partner at my law firm. I was desperately trying to explain to him what it's like when my screen reader crashes, and these problems I was experiencing with the JAWS not getting along with another program, a proprietary program. And the partner just goes, you're basically saying it's the blue screen of death, which, if you don't know, is like, when your computer totally freezes and it's a blue screen, and it's basically telling you, like, you can't do anything here. And I was like, yes, that's exactly it, right? And and it was what he understood then, the lack of control you feel, and how there's nothing actually that you can do to fix it, and there's also nothing that you did to cause it. So I just really, I want to reemphasize that that's such a great tactic, and the redundancy as well. My version of this is I actually recently testified at the Senate, the United States Senate, in front of the Senate Judiciary Committee, and like David, I've always learned to bring backups. And the exact same thing happened, actually. I was planning on pairing my cell phone with my Braille display to read my remarks, and for reasons that defy any understanding, for some strange reason, it did not work. And so I was a little bit panicking, but I was able to pull out my laptop, which was my backup. It looked a little less suave, maybe, but I paired the display to the laptop and was able to go. And so I think I think that kind of redundancy and that ability to think on your feet and to have a backup to your backup is so incredibly important. And it also it projects this image of preparedness and self-confidence that you are ready to take on whatever is thrown at you.
I'm just going to add, if I don't want us to monopolize this, but I'm going to jump in because Laura and I have never met, but I feel like we've known each other forever just through this exchange. But just two quick thoughts. One of which is we're kind of bookends because Laura's early in her career and I retired at after years of my career. And the longer you're in the office and more established, the more these things roll off a lot easier. When you're initially starting out, every junior counsel feels vulnerable, whether they're visually impaired or not, have a disability or not. I'm not diminishing what she's saying at all, much the contrary, I'm reinforcing it, but Laura, but initially we feel very vulnerable when these things happen. And we buck up and we handle them. And over time, as we get more and more established, we're able to ultimately shrug them off with greater ease. You're getting there. You're going to get there. It's part of the complete unfairness of the senior counsel, junior counsel reality of our world. The other thing which may help folks watching our session today is a good friend of mine once saw me working not in a law context but in another context in trying to sort of get folks adapted to working with someone with vision loss, and he said to me, "You folks are like somebody doing a slow dance, the old dancing like with one partner, and because one person leads." And he said, "David, it turns out that you have to lead, but you have to make sure the other person doesn't know they're being led. It has to be that natural." And in a sense, the strategies that Laura's talking about is exactly that, which is trying to lead folks, make them feel comfortable with us without hanging up a big flashing neon sign saying, "I'm leading you." And that strategy works, except when you get to the calamity like being invited to take part in a trial ad course with a pile of materials you can't read like tomorrow. At that point, you got to resort to other strategies like she did. Back to you.
No, I think the one thing that resonated particularly with me and I guess this comes through in both Laura and David's initial responses about being assertive and recognizing that it's not about you, because for me, it can often happen that if one is not able to get work done within the stipulated time frame, or if you think that something takes you longer, there's a tendency to weaponize that to feel bad about yourself or to feel inferior, and a sense of guilt that something must be wrong with how you are doing things that has resulted in being that way. So reframing it to recognize that is just a function of the structural reality of being a blind lawyer in an able-bodied, sighted world is, I think, a really powerful insight and one that we would do well to remember when things get difficult. So one question that I have for all of you is what, and some of this you've spoken to in response to the previous question, but what inhibitions or insecurities do you still have, if you don't mind sharing, as a lawyer with a disability in the profession?
I can go first again. So again, Carol, I felt so validated by your remarks because I also, I'm not muted, right?
No, I can hear you.
Okay. I also struggle very much with imposter syndrome that is related to my disability. I really do still think like, oh, maybe the work I'm producing isn't actually that great and they don't know what to do. They're holding me to different standards, all the classic things that come along with imposter syndrome. I don't know that I will ever actually totally get over that, but I think like my way of combating that, or my way of like helping myself to remember that I can't possibly be evaluating myself correctly, is to realize that, again, like we work in a we actually have a luxury in this way, some of the ones of us who don't work, who work in the private sector, in the sense that people are really paying us to give them the best possible representation that they can get. And there is no room, like people are not going to put money on the line for quote unquote pity or lower quality work. So whether it's like you have your own law practice and you know that clients are literally coming to you and saying, I want you to represent me, or for me as a junior attorney, it's more like a partner coming and saying, I want you to work on this case for me. Like they can't actually do that if they don't think that you're up to the task. And for me, that has been something, even though I do still struggle with it, that has been very liberating, that to realize that, for better or worse, people are going to be, they are going to be concerned about the profit margin or the satisfaction of their clients. And they're going to only ask you if they think you can really do it. So I think for me, that's my biggest insecurity. I also, the other thing that I will say, and I don't know if people can speak to this, is there are times when I make a decision in the in the spur of the moment.
Yes.
And this goes to the lead versus lead without showing them that you're leading. There have been times in my career where somebody will offer to do something for me, or to sort of, lead, like do something for me that in my normal everyday interactions, I would politely decline, or I would say, no, thank you. I'm capable of doing that myself. And I get a little nervous sometimes that if I'm too assertive in that way, especially with a client or with a very senior partner, that I will be seen as the sort of the angry disabled person or the ungrateful disabled person. So there have been times in my life where I have allowed the person to do something for me for the sake of seeming amenable that I normally wouldn't do. And that is a huge struggle for me, because I am constantly second guessing, was that the right decision? Did I end up seeming less competent because I allowed them to show me where the chair is, or whatever it might be in your situation? Or did I do the right thing in the sense that the conversation was able to continue to be about the work and not about whether this person can pour a glass of water? And I don't know the solution to that, but it is something that I definitely still continue to struggle with.
It's David. Here's my perspective on this. On the one hand, if you watched me in a courtroom or a classroom or in a TV interview, I will seem like the peak of self-confidence. And in some senses, that's not, I do have a comfort level doing those things. On the other hand, I am keenly aware that you're only as good as your last argument, and you're only as good as your last class you taught, and you're only as good as your last interview you gave. You could have 40 years of doing it well, but you go in and make a fool of yourself by doing a really terrible job, and that's what people may well remember. So I will undergo the same process of self-questioning and self-challenging that Laura talks about, because I want to make sure, no matter how comfortable or seemingly self-confident I am standing up to argue a case or getting up to teach a class or picking up the phone to give a radio interview, I still want to deliver the quality that my last one was if it was good, and not blow my track record if it's a good track record. So I go through that self-doubt, self-questioning constantly, and then after I'm done, I will re-look at an interview I gave and give myself a once-over. When I'd finish arguing a case, I'd turn to my student, either over a beer or a coffee or whatever, and say, what did we do right? What did we do wrong? What could I have done better? And they look at me like, you're expecting me to criticize you? But I actually want to, because I think it's good for us all to learn from it. This is going to sound nauseatingly cliche, but I tell law students that we call it practicing law for a reason. We are practicing up to the day we retire, and the point in time when you think that you know it all and that you're not practicing anymore is the time that your arrogance means you've got to get out of the business because you're going to mess up. So I actually think that all of this sort of theme that we're talking about is a very positive, constructive thing. And again, it's not We will focus on some of the disability-related stuff for understandable reasons, but people without disabilities who are in the law profession are either doing it or their arrogance is precluding them from improving. Back to you.
Thanks, David. My last sort of general question is for Carol, because she's not answered any, she not had the opportunity to participate in this segment of the conversation. Carol, would you mind telling us who your role models in the legal profession are, and if there's any advice that you have for a young person considering, with a disability, considering the profession in the law?
I'm very fortunate.
All of you, just a minute. I would like to bring to your notice that Mr. Rungta has joined us and he's presently in the meet. So we can continue with the question also, but just I wanted this to bring to your notice.
All right, so let Carol answer this question and then we'll ask Mr. Rungta to share his remarks with us before turning to one or two audience questions at the end.
Yes, surely.
Okay, so I mentioned that certainly 20 years ago when I sustained my injury, there weren't role models for me to look to. I am fortunate now that through the Queensland Law Society, I became a founding member of something called the QLS Diverse Abilities Network. And it's a group of lawyers that have disability and diversity issues that have set ourselves the task of welcoming other lawyers that may be student lawyers about to graduate or young lawyers in the early years of their career or any level of your career, where we might be able to be of assistance to make your journey into the legal profession a more enjoyable one. So I've met some incredible lawyers through that. And one of the things I was going to jump in earlier, but David was too quick for me. I wanted to just mention that one of the things we did from an employment point of view was we collectively put together an accessibility guide for employers, particularly large top-tier law firms, for all these things, Laura, that you're talking about, and David, that you mentioned. Very often when people don't know what to do, they do nothing. So it is part of this education to help make your life easier, instead of having to lead them, as you spoke to, Laura and David, that there's some sort of guidance given to these top-tier law firms that, look, these are the issues that you need to consider when you're employing someone with a disability, and also mention the plus sides as well. As to all the benefits as well as it's not just making accommodations here, there, and whatever. But I guess I have many people that I've met through this, but there are two that stand out for me. One of them is a wonderful young blind lawyer that is a litigator, and she is a real firecracker, and I'm very, very pleased to know her, and she's certainly someone that that gives me inspiration. And the other one is a gentleman that became a quadriplegic whilst studying medicine, and yet he went on to finish his medical degree, and being the show off and being the overachiever that he is, he went on to also change gear and finish his law degree. So he's not only, as to most mums want their kids to grow up as doctors or lawyers, and of course you have to be the overachiever and achieve both. He is actually Queensland's Australian of the Year this year, and he would be probably one of the many role models that I look to now.
All right, thanks very much for that, Carol. So now, Mr. Rungta, we would request you to share your initial remarks for about 10 to 12 minutes before we go to audience questions. I hope you had a chance to go through the prompts that we sent you. If not, I can reiterate those.
By and large, yes, I have gone through. But since I am very late, for which I would apologize, I will try to be very quick and focus to some of the issues that you have flagged. I would make some initial remarks about to give you an idea as to when I joined the profession, and that too litigation, way back in 1982. The challenges were enormous. Challenges of lack of accessibility of reading material, almost full dependence on braille, and non-availability of law book journals in braille, and probably not practical also to have regular journals in braille and voluminous law books in braille. In that background, I joined the profession. I'm talking of India. Maybe in certain developed countries, situation may be a little better at that time. Now, therefore, as a blind lawyer, choosing to pursue the profession as a litigating lawyer, not as a corporate lawyer or as an employment opportunity in some big law firms, which was also very challenging at that time if you wanted to take that path. So I decided to become a litigating lawyer. I chose this litigation as an option for my profession. Why I did so? As I said, other options were more difficult for me to survive, and therefore I thought that if I choose this path of being in litigation as a lawyer, I think it is my skill and wisdom, my capability, which will make or unmake me in the profession. Now, the first challenge was how to win confidence of the clients and get the clientage. Because unless you get the client to have confidence in you and he gives his or her case to you for protecting his or her interests, it is very difficult to show your capability and create confidence in your ability. I was fortunate in the sense that I had, if I may say so, a godfather. At that time, he was a senior IAS in Delhi government, Mr. Bajaj, who before I enrolled myself as a lawyer in 1982, gave me a letter empaneling me on the cases for being contested on behalf of consumers. As some of you who are conversant with Indian laws, land laws govern the Gaon Sabha lands, which are in a way public land owned by Gaon Sabhas. Large-scale encroachment. And the first case which was given to me was for defending the interests of poorest of poor who were allotted land in a particular village by Gaon Sabha. But they were out of possession, they were never given possession, and those lands were encroached. The matter was before High Court. I used this opportunity in order to establish my identity from the first case itself as a person who could deliver. I prepared for 4 days and then I appeared before Justice Ward. As some of you might be knowing from India, Justice Ward was a very judicious but very difficult and technical judge. Be that as it may, my preparations helped me. I had extensive bail notes, because let me tell you that even now I extensively use bail notes. The only methodology has changed. Now I take bail notes wherever it is permissible to use computers. I take bail notes on pen drive. Otherwise, I take my bail notes in hard copy of bail notes for my reference. And this has been, in fact, a scoring point for me, use of bail. Every time when I am before a new judge, even now I am saying that they mostly see how best can I read my bail notes and refer to the relevant pages by reading it in bail. To a great extent, this has helped me. But as I said, the challenge to have update knowledge of developing case laws on given subjects was an issue which I had no other alternative but to depend more on the reader's help and help which was available from my cited colleagues and my family members. I must frankly admit that in the initial years, unless the technology, I could become a little bit technology savvy and could use technology for ensuring accessibility, better accessibility during arguments, during preparation of pleadings, during preparation of evidence on behalf of the clients. So, on the issue of winning confidence of the client, I would say that you will have to capitalize on the first opportunity that you get. And therefore be selective for the first case. Be selective if you are 100% sure that you could do justice to that case and get relief. Then only take that case as a first case when you enter the profession. It is very essential for us lawyers with disabilities and particularly visually impaired lawyers to be selective in the first instance. I know what I am trying to convey. This is also a very difficult task to do, but that is the, I would say, that selection of that case helped me to establish myself as an expert on land laws. I can tell you that initially I was even treated to be the most knowledgeable on land laws. And there are very few advocates who are well conversant with land laws. And very few choose that option or that line of law. Now, flowing from this experience of this case, I would also like to share with you that it is easy to create confidence in you among illiterate or semi-literate persons rather than on very literate and educated persons. Coupled with it, it is very difficult to create confidence in the abilities of disabled lawyers in the corporate world. When they have so many options, they would hardly choose a disabled lawyer. That is my experience so far. But if you create the confidence in illiterate or semi-literate people, they send the message across, and that creates your client base that I must share with you out of my experience. At least I developed my client base from there. And then, like a pyramid, it went to other segments also. And finally, to the corporate also I could reach. So that is the part on the issue of how do you win confidence on the client. Now I will very quickly go to the very important aspect which you flagged in about the trial, conduct of trial by particularly by a lawyer with visual impairment. There are issues which have been raised by the courts also. And I would like to quote one. I often quote it in such deliberations. And this is a real example that I am giving you. There was a probate case in respect of a will executed by a blind gentleman. Beneficiary was also blind, and the witnesses to the will, attesting witnesses, were also blind, and lawyer was also blind. That is me. When I was adducing evidence of one of the attesting witness, the judge stopped me. He squarely asked me how this blind person can adduce evidence without seeing his signature. How can he confirm? That it is that very will which he attested as a witness, as one of the witnesses. My answer was that he will do it after having the document read over to him, and based on that, he will confirm or refuse to confirm the execution. The judge did not agree, and we had a very heated argument. It went on to the extent of saying that all of you, including lawyer, are blind. So why should I not discard the evidence? And he in fact passed an order, which I challenged, and that was reversed. So that is one aspect of the evidence about the competence of the evidence of blind person with regard to a document. Now, after Rights of Persons with Disabilities Act 2016 coming into force, this issue cannot be raised again because legal competence of being a witness and adducing testimony by persons with disabilities has been recognized as a right. So no court now can raise any question on that count. The second aspect, again regarding the chart, is very important, which you have also flagged. How do you understand and develop your argument or prepare your witness in those cases where visual displays are there or documents of visual nature are to be proved? For example, in a property dispute, there is a site plan, supposing, which your client wants to rely upon or dispute. Now, in order to prepare his evidence in respect of that map or site plan, first you must understand as a lawyer actually what is your client's case and how do you visualize. Then only you can develop your questions. Now, how do I do? Because I have done many cases, as I said, in land laws where maps, etc., akshazra, etc., were to be proved, or questions around that have to be put to the witness of other side. What I did in that case, now I am no longer, after having been designated senior, I am no longer conducting trials. But so long as I was conducting trials also, what I have been doing in such situations, I have been trying to create, with the help of my colleagues, a sketch in my mind and to understand the actual dimensions, actual position of a particular area which is the subject matter of the case, and then try to visualize as to what is the best what is in the best interest of my client on the basis of the pleadings that he has set up. And on that basis, after having made a kind of sketch in my mind, in my memory, I would say this visual display or map having been converted into my memory, understanding, a kind of visualization in my memory and in my wisdom is the only alternative to do all this. And I have never failed in that by adopting this. This much I can tell you. We can go on and on this aspect, but so I say to say that whether on trial side or appellate side or writ side, I always start from the weakest point of this and explore the answers there. And then when I don't find answer to any weakest point, I strategize how to escape the query being raised around that and what would be the method to try to bury it by raising a better strong point in your favor. The question of comparative merit of the arguments on those issues could be a strategy to bury them up where you are weak. That I have successfully resorted. Now, lastly, when it comes to the what is the best for a person with visual impairment, particularly while litigating, while acting as a litigating lawyer, I take appeal and writ jurisdictions are better than original right, because of the fact that issues of evidence and all those problems may arise, and any problem in your understanding of, say, for instance, map or about the authenticity of a document, whether the signatures are forged or not. On that, if you have not completely understood the nitty-gritty of that visual part, then probably you may land up in conducting the trial in a manner which may be injurious to the interest of the client. So therefore, safe way is appeal and writ, but at the same time, nobody would give you a brief of appeal or writ in the first instance. Unless you are established, you cannot go to that level, and therefore you have to start the trial. I would once again apologize for being late, and I'm open to any questions that you may wish to raise.
Thank you so much, Rungta. It was very informative to hear you describe in very concrete detail how in your career you dealt with obstacles that prima facie seem insurmountable for a person with a disability to do, and how you've been able to establish for yourself a career worth emulating for other lawyers with disabilities in India and beyond. So now in the remaining 10 minutes or so that we have, I propose that we take some questions from the audience. Can someone facilitate that? Can someone read out questions that people have asked?
Rahul, are there any questions? Madam, no question.
No, sir. There are presently no questions from the audience, neither from the Google Meet platform as well as not from the YouTube.
Okay, then I think I will ask one question, and probably Deshpande sir wants to ask one question, and then we'll go for vote of thanks. Rungta ji has
I also have one, so after you two, if there is time, I will put that.
Yeah. And I promise you that I will not let you not go for a long time. We'll finish within time. Now, Rungta ji has spoken in great details about his experiences as a trial court lawyer in India. I would like to hear from David, his murder case, his experience of conducting murder case, very briefly.
Okay, I didn't do murder trials, I did appeals. So I've appeared on a few constitutional motions at the trial level, but whatever be the appeal, whether it's a break and enter or a murder, it's basically the same thing. You'd have to read the transcript. I fortunately was able to get these. My assistant, who was amazing, she sadly passed away a couple of years ago, but we became close friends and she worked with me for 20 years. She would get the transcripts from the court reporter in Word so I could read them. And I would read the transcript myself. I would, with assistance of law students, piece together the argument that I'd want to make. I never delegated reading transcripts. My view was I wanted to read everything. And then off I would, go to court. And once we reached the point where court decisions were all online, and therefore you could get copies of cases that people are citing or that you're citing and have them available at your fingertips and be able to load them on laptops. It wasn't until some point in the 90s when we could load them on a laptop and physically bring them to court. It was transformative in the convenience of being able to do this and literally read and write anywhere I wanted to go. And that was enormous. And I mean, to me, oral argument is my favorite thing in this profession. I loved being up on my feet. And because I was arguing for the Crown in the criminal appeal context, we usually went second, which meant my opponent, we'd received their brief in advance, their factum, and I knew what they said they were going to argue, but what came up in the courtroom was often different. So I had to maximize the capacity for extemporaneous response. And I mean, for the benefit of this audience, I mean, one of the biggest challenges is knowing what's on the judge's minds, because they could be yawning or looking away or whatever, or making a face, and I don't know. I would ask my law student for prompts on some of that information, but I often tried to. I mean, the pinnacle of oral argument is getting questions from the bench and then being able to engage them, and that for me was the high point, because then I'm getting some insight into what's troubling them about the case or what worries them about the case, and so on. So that that for me was the peak. And the other thing that, frankly, I loved was when a judge brings a laptop to the courtroom, because if I say something and then I hear their keyboard clattering, I know I've done either of two things. Either I've made a point they think is worth keeping note of, or they've decided that they've got a dozen eggs they want to make sure they pick up on the way home, and they've made a note of it. Of course, I won't know that till it's too late. Back to you.
Yeah, Deshpande sir, you want to ask a question? Rahul,
yes,
would you like to ask a question?
No, Dr. Deshpande wanted to ask, right?
But I'm not able to hear him.
Okay, until we get him on board. I have a question about one thing that Mr. Rungta said in his remarks about how, for instance, if a corporate law firm has to choose which counsel to hire, they are unlikely to hire someone with a disability given all the choices that they have. So my question, and I would love for anyone to, we can start with Laura, but anyone who wants can answer. How would you respond to that statement of cynicism in a constructive way, where people just feel that they would be better off having someone cited do the job instead of you?
Rahul, just to intimate you that Miss Laura has left the meet, as well as Miss Carol Taylor has also left the meet.
Oh, I see.
So Rungta sir can answer. Rungta ji can take on that.
The only way, I said, that's why I decided not to go that way.
Yeah.
And because I still feel, if you look at at least of India, I know,
yes.
You look at the big corporates and corporate firms, law firms which deal with the big corporates, even for that matter, medium level corporates, you will find that there are only big names. It's very difficult to find a person who is struggling to establish, in spite of the fact that he may have at times better knowledge than the person hired.
Yeah.
But your disability, our disability, in fact, is an impediment for them even to think of hiring you.
Yeah.
I will give you one very concrete example. Until I was designated senior I had only one or two big corporates or law firms who could at times, I am not saying regularly, who would at times hire me.
Yeah.
But that hiring, if I go back and retrospect, that hiring was in those cases which were refused by others.
Yeah.
Because they knew that in any case we are not getting it, right? Why not try? That has been the approach.
Yeah.
But
David, do you have sorry, please continue. Yeah.
No, but I'm just finishing.
Yes.
But luckily, in one of such instances, I could get the relief,
Yeah.
which was treated to be dead,
Yes.
not possible. And that very corporate, then started hiding and is still hiding.
Yeah.
So, what I am trying to say, the only answer is give your best if you want to establish yourself.
Yes.
Now, can you hear me, sir?
Yes.
Yes.
Can you hear?
Yes.
Yeah. Last question.
Last question. Yes.
Rungta ji, good evening. I was really
Good evening, sir.
very much impressed by your articulation of the problems which you have faced and how you overcame them. Just one question which was raised yesterday by Professor Sandra Friedman. He was asking whether lawyers alone should lead the disability movement. Is it likely to alienate others? That was the question.
Lawyers alone?
If lawyers alone lead the disability movement, will it alienate others from your movement?
It's David. Can I answer that?
I would say
First, Rungta and then David.
It's not the question of who is leading the movement, which profession he is pursuing.
Yes.
The real, to my mind, whosoever is leading, belonging to any profession, right, must understand the issue, must be well conversant with the policy and legal paradigm, and also must know what is the best strategy to reach where we have to reach.
Correct.
So, for me, it is, I don't think if a lawyer is leading the other segments would feel alienated. No, I don't think.
Thank you so much.
Yeah, David.
I don't think any profession has a monopoly over anything, and I think that whoever takes on a leadership role, if they, whatever be their skill set, the question is, can they collect up people's views and effectively articulate them? And I'm pleased to say that here in Canada, the many of the people playing leadership roles are either are not lawyers or maybe have no profession. Maybe I don't even know in many cases what their training is. All I know is if they can raise a barrier, get public attention on it, appear before a committee of Parliament or the legislature in Ontario or whatever it may be, or can blast away on Twitter, that's the measure of being effective, not their credentials. And I also, it's much longer than this panel, which is about to wrap up, will have a chance to address, but I think the future of disability advocacy is going to be very different than the past. And that will include, people, if they could just take an issue and raise a credible voice, whether it's on Facebook or Twitter or wherever it may be, and build action on it. It may not be that they formally lead any organization at all in the traditional sense of NGOs. And so I think that the capacity to use social media platforms and otherwise to to get voices out can be used to effectively strengthen us. But I don't think the question should one profession play a leadership role or does it alienate and so on. I think if people see success, they're happy, and that doesn't matter what your credentials are.
Wonderful.
I guess this will be my last time talking, so thanks again for including me.
Yeah, thank you so much, David, and thanks everyone for. This has gone on for more than 2 hours now, so that this evidences the amount of interest that everyone involved has had in the conversation. So thanks everyone. Laura and Carol have unfortunately left, but I will write to them privately to thank them for their participation. And I'll hand it over back to Varsha ma'am and Sanjay sir. Wrap it up.
Yeah. Thank you, Rahul. Thank you all the speakers as well as Rahul for wonderful moderation. So we come to the end of the second day of International Summit for Legal Professionals with Disabilities. Before we close down, I would like to put on record the active support and honest contribution which have been made by today's speaker, Mr. David Lepofsky, Mr. S.K. Rungta, Ms. Laura Wolk, Ms. Carol Taylor. Thank you all. I would also like to thank Mr. Rahul Bajaj for his excellent moderation of the session. My word of thanks also goes to the management of ILS, Ms. Vaijayanti Joshi, Director, Academics and Administration, ILS Law College, Principal Dr. Sanjay Jain, the entire team of ILS, our collaborators, Harvard Law School Project on Disability, Oxford Human Rights Hub, Center for Disability Studies, University of Leeds, London, Publicity Partners, Bar and Bench, and Media Partner, Sudan. I also thank all the participants for your active participation. Thank you one and all. Just a gentle reminder that tomorrow our third session will be from 10 a.m. till 12 noon according to the Indian Standard Time. See you all tomorrow in the morning. Thank you.
Thanks a lot. Thank you.
Thanks, everyone.